Greetings, everyone, and thank you for joining us for today's webinar, Workforce Masterclass, Best Practice Considerations in Independent Contractor Compliance. My name is Cynthia Woods, and I'm the Vice President of Marketing at AccuSource HR, and I will be today's moderator. Before we get started today, we do have a few housekeeping details. It is my pleasure to now introduce today's panelists. First, we have Doug McGraw, General Counsel at OpenForce. Doug began his career serving the transportation industry with a company by the name of DART Transit Company, and from there has had a 17-year career in supporting the legal aspects of independent contractors. We also have Jennifer Damon. Jennifer Damon is the Vice President of Compliance and In-House Counsel at AccuSource HR. Jennifer has over 10 years of experience in background screening, and she graduated from the University of Akron School of Law with her JD degree. She is experienced in background screening, both from the client side and from the CRA side. And she has overseen both E-Verify programs, audits, and other background-related services for a billion-dollar facility services company. She's also experienced in government clearances and contract reviews. And Jennifer is currently responsible for AccuSource HR's compliance department, as well as overseeing our quality assurance process. Well, thank you, Doug and Jennifer, for joining me today. I really appreciate it. So our main topic of discussion today is, as of about January of 2023, about 10.1% of the U.S. workforce was self-employed. And independent contract work has been up significantly since the pandemic at about 73%. The number of full-time independent contractors increased by 23% in 2023, reaching a now 26 million independent contractors in the overall workforce. While some workers are eager to go back to work after the pandemic, some people decided to choose another path after they had experienced what it was like to kind of control their own destiny. And so that's another reason that's given a significant rise to independent contractors in the workforces versus our traditional W-2 workers. So utilizing independent contractors or a contract labor force does afford organizations several benefits, including specialized on-demand talent, supporting larger capital projects, ensuring scalability for increased growth, and potentially reduces overall labor cost. However, managing a 1099 workforce and its compliance requirements can be very challenging for organizations. And that is why we brought this panel together today to kind of discuss some of those challenges that you can encounter and what are some great opportunities to overcome them. So with our very first question, we will go ahead and, oh, you know what, I take that back. Before we jump into our questions, let's go ahead and do a poll question. So our first poll question is, what percentage of your current workforce is comprised of independent contractors? And to answer that answer, just simply pick whichever option on the screen seems to emulate the situation of your current organization. And we'll give just a minute for everyone to kind of finish that poll. Looks we have a couple people that are still logging in their questions. We'll give it just another couple of seconds. As I still see some responses jumping in. Okay, Let's go ahead and reveal the results of our poll. So it appears that that the highest number for that the highest response is that independent contractors are a key resource in your organization, or that you are utilizing approximately, you are utilizing some independent contractors. It looks like, our next largest category is that greater than 50% rely on, very heavily on their independent contractor workforce, where we have just a small percentage that does not utilize independent contractors at all. And this is pretty representative of what I've seen in the workforce, is a lot of companies are now tapping into this resource to be able to meet their business objectives. So that should take us into our first question. So Doug, can you share with me what are some of the key differences between 1099 labor and W-2 employees, and how can organizations avoid misclassification challenges?
Thanks, Cynthia. Appreciate it. Happy to be here and help answer any questions however I can. So I would say I want to kind of answer the second part of that and then kind of go into the first part. I would say if you're going to have a good independent contractor program, and to me, here's what a good independent contractor means. It really has two aspects. First is it is financially successful for everybody involved, meaning the independent contractor is getting paid an appropriate amount for their services and for their equipment or their whatever they're providing to the table, bringing to the table, as well as it is leading to the ability to provide services, make money, and all that kind of stuff for the contracting company. So that's part one of being a good independent contractor program. And part two is that it is legally compliant. And so to do those things, I think you have to start with a fundamental kind of get it through your head. The independent contractor is a small business. Now, it's not Target Corporation, it's not Amazon, it's not some giant corporation, but it is a small business with sales needs and cost management needs and staffing needs and all that kind of stuff. And if you think of independent contractors as small business vendors that you're utilizing, and you keep that thought in your head as you design all of your interactions with them, as you design your contracts, as you design your pay, as you design your operations, if you keep that in mind, you're probably going to do things pretty well. So I would say fundamentally start with that approach. Otherwise, kind of the characteristics that you'll see in an independent contractor program, and I'm not ranking these, but common things you're going to see. That independent contractor has business choices. They have the ability to turn down work opportunities. They have the ability to kind of set their hours. They have the ability to make decisions about who is going to work for them. They ultimately control how they're going to do the work. They have the ability to serve more than one customer, and hopefully they take steps to. And I think a part that's not maybe talked about enough is the pay should be different. If they shouldn't be paid like a W-2, and I don't mean just from a tax perspective. I mean is if you're paying, if you would pay an employee $20 an hour to do this service, presumably you're going to pay a contractor more than that, because a contractor's got to be responsible for more business costs. They're going to be responsible for benefits. They're going to be responsible for their own operating expenses and so forth. So the economics of the deal should be different than they are with an employee, because that's where a lot of people will talk about. I use independent contractors because they're cheaper, and I kind of furrow my brow with that a little bit, because in my experience, independent contractors are cheaper in some ways, but it's not universally. They're just cheaper because you're paying them different. I always say is independent contractors and employees cost different, and sometimes that means one is cheaper or more expensive than the other, but on the whole, the cost is different. So kind of go back to what I'd say is it an economically good program? Are you legally compliant? And does the contractor have choices, meaningful choices that show that they are in business and that they're making decisions that either lead to them making money, making a profit, or they make decisions that lead to a loss? That's what a good independent contractor program looks like.
That is great feedback. And I know that, you kind of want to begin with the end in mind. So starting with a solid, contracting and onboarding processes with your independent contractors can also be very key to having a great relationship with them. Can you share some additional information on this subject?
Yeah, so think of building an independent contractor relationship, a good independent contractor relationship, like building a house, or building your next office building, or whatever the case is. You have to have a great foundation, right? It doesn't matter how fancy the kitchen is if there's no foundation underneath it that actually can hold it all up and keep it all together. So it starts with a good contract, and just as importantly, in fact, I would argue more importantly, a good contracting process. And it needs to fundamentally not look like a hiring process. So and we'll get into, Jennifer and I will get into, there is some things that apply regardless of whether or not there's an employee or an independent contractor. There are some things, and we'll talk about those things. But many things are very different. So for example, you want to make sure that your independent contractor contract is simple and easy to understand. That doesn't necessarily mean it has to be really short or anything like that, but don't make it 6-point font with no white space and really hard to understand, and a lot of heretofores and therefores and whereins and all that kind of stuff. Make it easy to understand. Make sure the terms are reasonable. Every court, every agency is going to look at you as the big bad company and the worker as the small disadvantaged person. You want to take as much of that argument away. Present your terms, present reasonable terms to the contractor, and then when you're contracting with them, don't slide them a piece of paper and say, sign this and now we're ready to get going, and sign this or else. Give them an opportunity to make choices. I have I'm with Open Force, and Open Force, one of the things that we do is we build in options for contractors. Then whether you use Open Force or use someone else, I'm not here to sell the product. What I'm here to say though is, when you're working with independent contractors, make sure there are choices for the contractor to make in the way they work with you. The more you can show in the contracting process, as well as in your day-to-day operations, that the independent contractor made business decisions, you are going to have a better and better independent contractor program. And think of that right at the beginning with that contracting process. Get those contracts online, because it's way easier to administer them. Make them easy to understand, easy to digest in a mobile format or an online format. Build in choices, use technology to build in choices in benefits, choices in insurance, choices in their staff, and so on, and you'll have yourself a good program. Starts with that good foundation.
It's a great answer, and thank you. That is some very positive feedback, and really it sounds a lot like you need to treat them like you would treat any other vendor, and with the same level of respect.
That's exactly right.
Perfect. Well, I think that puts us right into another poll question. The question should pop up on your screen in just a moment. So, have you ever encountered compliance challenges in contracting or onboarding processes with your independent contractor workforce? And your options should be on the screen now. We'll take just a moment and give everyone time to consider that question and provide us with an answer. Okay, I think this was a little easier to grab an answer on. So we'll give it just like another maybe 5 seconds. Oh, perfect, and the poll is closed. All right, so let's look at the results. Okay, so it does appear that we have about 47% who have encountered some challenges in the past. It looks like about 39% feel that they have pretty good practices and policies in place and haven't encountered any issues, and about 13% that are currently not utilizing independent contractors. So, and that, that high number of 47% that, actually have encountered some challenges in the past is pretty much in line with what, we have heard from clients as well, is that it can be a really tricky process, and having some good partners in place to help you out is great. And also having great, knowledge resources that you can tap into to ensure that you're doing the program right.
Can I make a comment there, Cynthia? Is that all right?
Oh, absolutely.
Well, I'm not at all surprised to see the numbers too. And what jumps out at me is with independent contractor programs, you do need to mind the details. You heard me talking about building the choices and so forth. Well, that's great to build the choices, but you also have to watch what the choices are. So the contractor should have the choice. Do they want to be a corporation, an LLC, a sole proprietor, or whatever? It's great for them to have the choice. But what's not great is they selected that they want to be an LLC, and they told you they are an LLC and that they're Joe Smith Services LLC. But then in the contract itself, they just wrote Joe Smith. They didn't write Joe Smith Services LLC. That's a type of a compliance issue. Is does your contracting process, and this is where I think technology can help, rather than the old school paper files, the technology can help make sure, well, if Joe Smith said he is Joe Smith Services LLC, that all of the paperwork is in the name of Joe Smith Services LLC. So I'm not at all surprised to see the numbers. I run into that all the time, and it's about minding those details.
Absolutely. It's funny, background screening is another area where potentially there can be challenges with independent contractors, especially if you're very used to doing background screening on employees. So at this point, I'd like to kind of pass it to Jennifer. So what are some of the places where there can be confusion, in independent contractors versus employees? And can you share some of the background screening requirements in regards to the Fair Credit Reporting Act and, state and local protections that are extended to both contractors and W-2 employees?
Absolutely. So first of all, the background screening differences and similarities for ICs, independent contractors versus standard employees, can be very, very confusing. Sometimes it takes delving into the state and local laws specifically to see how things are defined, to see how people actually need to be treated when you're screening them. So first I want to discuss some of the key background screening laws that impact both employees and independent contractors. I'm also going to point out some of those differences between them, as there are some nuances. So most of the time when you're hearing about background screening, a lot of people automatically assume employment screening. We're going to screen standard W-2 employees. That's not actually true. Under the Federal Fair Credit Reporting Act, or FCRA, there can be a variety of reasons to conduct a background check on someone. Those are referred to as permissible purpose, which is your legitimate justification, your legal reason for having the authority to request that background check. So employment's one of them. There are a variety of others. I'm sure all of us at some point have gone to either rent an apartment or apply for credit for a car loan or a mortgage. You likely would have signed an FCRA disclosure and authorization. If you didn't, that's a problem for another conversation. But there are different permissible purposes and reasons to have a background check. As mentioned, the FCRA is the main law that covers background checks, and then there's also state and local laws. The FCRA does have requirements that apply to both independent contractors and traditional employees. As mentioned, permissible purpose is important. In order to provide that separation to avoid misclassification issues and concerns, we would use separate permissible purposes. If you have an employee, that permissible purpose is that the report's going to be used for employment purposes, employment screening. before you actually request and procure that report for employment purposes, you as the end user have to provide a clear and conspicuous disclosure to that individual that you may obtain a consumer report for employment purposes. And that disclosure and consent must be in writing. I mentioned misclassification is a huge concern, very well aware of that. That's why it's best to use a different permissible purpose. So for independent contractors, instead of for employment purposes, the permissible purpose could be with the written instructions of the consumer. So for example, a sample language for that disclosure could read, company ABC may obtain a consumer report at your written instruction for the purpose of granting access to company ABC's property to perform service. So it's very clearly delineated that there is that written consent. It's the written instruction to do so, but there's no implication that there's an employment purpose, which helps avoid misclassification issues potentially. And in essence, I know I mentioned the employment purpose has to be in writing. Same thing in its nature, because it's the written instruction of the consumer, that also is in writing. So both of them have to be in writing. Keep in mind, that's just the standard consumer disclosure I mentioned under the FCRA. If your company is going to perform reference checks or verifications on an individual and it's more opinion-based, say you want to call someone that, like a prior customer of that independent contractor, and ask, how did that person do? Would you recommend them? In that case, you would also need to provide and obtain consent for an investigative consumer report, because it's more opinion-based. It goes into a deeper dive than the traditional standard background screening report. Any other thoughts or questions before I move on to some of the other topics? There's a lot to uncover here with the difference in the FCRA.
You know, Jennifer, I know that there's a lot of similarities on the federal level. Are there, like, do people ever run into challenges with independent state laws or independent particular laws that are relevant to a certain municipality in regards to either treating independent contractors different or treating independent contractors the same as individuals that are, you know, actual W-2 employees?
Yes, we actually run into this all the time when we discuss it with our clients who use independent contractors. I mentioned earlier that it's very important to really read those laws very carefully to see how employee is defined. So for example, New York City Fair Chance Act, very, very specific requirements. There's a form that needs to be filled out, or at least you must provide the same sort of analysis, even if you don't use their actual form. It appears, and it's implied by the nature of the form, that it's for employees only. But if you delve into the definition section of the New York City Fair Chance Act and look at the guidance, they specifically state that it also applies to independent contractors and unpaid interns, just in case anyone has any of those in New York City. So at that point, it may be a good idea to kind of tailor your analysis or form, if you're going to use their sample form, to remove the employee references, but replace it with independent contractor. That being said, because independent contractor is specifically included within that definition, if you're not providing that same analysis and following that process, you could get into a bit of trouble with that. And New York City is very particular about their laws, because the goal is to prevent discrimination, not only against employees, but also independent contractors. Another one that I could think of off the top of my head, City of Los Angeles. They also specifically define that there are independent contractors who are included within the definition of employee. And keep in mind, this doesn't only have to do with the Fair Chance Act itself, but there can also be very specific disclosures that are required up front. I mentioned earlier that there's the FCRA disclosures. If a person lives or will work in a certain state or locality that has its own disclosure requirements, it's very important to review those to see if it applies to employees only or also independent contractors. For example, City and County of San Francisco and City of Los Angeles, they both have disclosure requirements. Again, on its face, without really reading the definitions, it seems to apply only to employees, that you need to disclose that on the front end before getting authorization. But when you look at the definitions, independent contractor is in there, so you have to provide it to them as well.
It sounds like that, that your requirements could be very situational depending upon where that employee either works or resides, whichever laws are there to protect them. So let me ask you a question. So what about if there, something comes up on the background screen, or a person, tests positive for illicit substance or something of that nature, and a organization deems that this person is not suitable for contracting? How would the organization proceed at that point?
Absolutely. So this is referred to as the adverse action process under the FCRA. There is precedence for treating independent contractors and employees the same for adverse action purposes. Specifically, there's an FTC opinion letter that states this, as well as court cases. So what exactly does the adverse action process entail? So when you're screening both employees and independent contractors, before you take a final adverse action, such as either revoking the conditional employment offer, or if it's an IC, rescinding the contract itself, the report user, the end user, whether it's the employee or the contracting company, must take certain action if it plans to take a negative adverse employment or contracting action based in whole or in part on that background screening report. Specifically, it's referred to as a pre-adverse action letter. Technically, the FCRA says that these letters can be oral, written, or electronic, but honestly, best practice is to put it in writing, which can include electronic copy. So for example, we have the ability within our platforms, and we have managed adverse action where we send out the letters electronically. So even though it doesn't have to be in writing technically, it really is best practice to have it in writing, because otherwise, how are you going to prove that you sent it if you're providing it over the phone or in some other manner? The letter itself has to include some information about the background screening company that provided the report. I'm not going to get super into the details here. And it also has to include a statement that the background screening company itself did not make any adverse decisions, and they can't provide specific reasons as to why adverse action may be taken. It also must include a statement of the right to dispute the findings with that background screening company that provided the reports. Along with the letter, you also must provide a copy of the FCRA Summary of Rights. Literally just summarizes the rights that that individual has under the FCRA, and then also a free copy of the background screening report. So once that pre-adverse action letter is sent, and keep in mind, this applies to both employees and independent contractors, the end user of the report, so the employer or contracting party, must wait a designated period of time before taking that final adverse action letter and sending it out. The FCRA itself doesn't actually have a specific time frame, but general best practice and court opinion has been 5 days is basically the acceptable time period. Keep in mind, and this is where some clients may have questions, in some of those smaller jurisdictions, states or localities, there may be a longer waiting period. For example, City of Philadelphia requires 10 days between the two letters. The purpose of this waiting period allows that individual to review their report and reach out to the background screening company if they have a dispute. So if they feel that something that the background screening company reported is either inaccurate or incomplete. At that time, if there is a dispute, typically the background screening company notifies the end user. The process is paused, dispute process goes through. So assume that either there's no dispute or everything stayed the same after we reinvestigated as the background screening company. If that's the case, then at the end of that waiting period, the end user can send that final adverse action letter. Keep in mind, we mentioned the Fair Chance Act laws earlier. There are different requirements for certain jurisdictions. So, for example, under the FCRA, you're not required to list out the specific reason that you're taking adverse action. California, you have to list out the specific conviction or convictions that are leading to adverse action or did lead to adverse action. New York City, which we talked about earlier, there's a specific individualized assessment that has to take place. They have a form that's very, very easy to fill out. You just fill it out, meets the requirements of the assessment. You send that with the pre-adverse action letter. So just keep that in mind. It may be a little bit more complicated than just sending out 2 letters based on where that individual lives or works.
So it sounds like there is a lot of crossover between an independent contractor and a W-2 employee in the adverse action process. What about the EEOC? You know, there's EEOC guidelines that are extended to employees, and you know, obviously it's the Equal Employment Opportunity Commission. So you know, by its very name, it kind of seems like it leans more into an employee than into an independent contractor, but from what you said earlier, a lot of this language with the individual states also leans heavily into an employee versus an independent contractor, yet there's an inference that both should be included. How about EEOC? What's the impact there?
Yes. So first I want to point out that both the Federal Trade Commission, or FTC, and the Consumer Financial Protection Bureau, or CFPB, they've both held that independent contractors should be treated under the employment purpose for the FCRA, as we discussed earlier, for the adverse action process, consideration, etc. So moving into the EEOC discussion specifically, it's important to kind of understand the reasoning behind the EEOC and its guidelines for the use of arrests and criminal convictions. Ultimately, those guidelines, even though they're guidelines, ultimately people can bring cases through the EEOC. So if you're not complying with them, it could result in a problem. So they're technically guidelines, but in reality, they are enforced. Ultimately, those guidelines require that employers do not have a bright line rule of denying employment to anyone who has any type of criminal record whatsoever. So, for example, if you have your hiring policy or contracting policy, and you say, if anyone has ever had a felony, I'm not going to consider them. They're automatically barred, no matter what it was, no matter when it occurred. Someone could potentially have a driving under suspension felony from when they were a teenager, from 20 years ago. You have to ask yourself, is that relevant to the position? So bright line rules, not a good idea under EEOC guidelines, and those Fair Chance Act laws we talked about earlier, same exact situation. Try to avoid bright line rules. How to do that is you look at what are referred to as the green factors under the EEOC guidelines. Those factors allow you to conduct an individualized assessment to really consider, does the specific conviction or offense relate to the position? What's the risk here? what benefit of the doubt should I give to that person based on timing? The factors include the nature and gravity of the offense or conduct, the time that has passed, and then the nature of the job held or sought. So for example, the duties that are performed. By assessing these factors and the specific facts that apply to that individual, the record, and the duties of the position, it provides a good balance between protecting the company while also providing opportunities for those who do have criminal records in their past. Same process applies to independent contractors, especially as we've seen in City of Los Angeles and New York City, where it specifically requires the same type of assessment for those individuals. So for example, in New York City, if you're filling out that form for independent contractors, it literally asks you to go through those green factors to determine, okay, so this person is going to have access to money because they're in the financial office. They have access to company credit cards, bank information, and they were convicted of felony embezzlement 3 years ago. That's going to be more realistic to say we're not going to hire or contract that individual because there's specific information, a specific conviction that ties into the duties of that job. That's going to be more reasonable when looked upon by the EEOC if there is a claim. Ultimately, it's best practice to conduct individualized assessments for both employees and independent contractors. Have that in writing, because ultimately, if you don't have it in writing, how are you going to prove that you actually did that individualized assessment?
Perfect. That is some really great feedback, Jennifer. And it sounds like, you know, having a really good partner who can help you navigate through some of these complexities can be a great asset to any organization in ensuring that they maintain, you know, very, very solid compliance. Now seems like a great time to do another poll question. This will be our final one. So if everyone can get ready for that poll question. And the question is, one moment. And the question is your organization currently creating a clear separation between W-2 and 1099 workers in your onboarding and labor management processes? In other words, do you have a bifurcated or separate process for each work type? So I'll give everyone a few minutes to go ahead and answer this question. For a few moments. It looks like we got a couple more people that are putting in their answers. And thank you, attendees, for your great participation in these poll questions. They really are helpful to gain an understanding of where organizations stand today. Okay, and I think that's probably the majority of everyone. Okay, so it looks like we have about 76% of the attendees that have indicated that yes, they do have bifurcated processes or separate processes for their W-2 and 1099 workers, and that they do try to keep those two work groups very, very separated. We do have a small percentage that said no, and so, you know, for our no attendees, if there's anything that, you know, either our organization can do to help you out or Open Force can do to assist, I mean, please, you know, just let us know. But it is, you know, from what Jennifer and Doug have both indicated in today's webinar, it is very important to have that separation so that you don't have misclassification issues. And then obviously we have our same small percentage of organizations who currently don't have an experience to share, as they're not currently utilizing independent contractors. At this point, I would love to go back to Doug and get some additional feedback. So Doug, utilizing a third party to assist with contracting and onboarding services is a great option to create separation and ensure that expert support. Can you share some of the benefits, you know, from your perspective of using that independent contractor third party for compliance management and for contractor onboarding?
Yeah, happy to. And to me, there's two reasons to do it. And again, I'm not ranking these two because I think they're both very good reasons to do it. But one is going to be the appearance, the legal separation between the contracting world and the employment world. You want to make it very clear to the outside world that you didn't hide anything, that this was open and obvious, that this was an independent contractor relationship. You have to assume for a moment that when you get a claim from someone claiming that they were misclassified, that they were treated as an independent contractor when in fact they were employees, they're going to argue all sorts of things about, they hired me, they fired me, they treated me like an employee, they talked to me like I was an employee, I filled out employee forms and all that kind of stuff. You want to take away as many of those arguments as you possibly can. And one of the ways you do that is by not putting them in your HRIS system, not having them fill out employment forms. Jennifer hit on it. There's a lot of overlap in your obligations and the best practices of how to run background checks and investigate people. And there's a lot of overlap there, but there are still some critical differences, as Jennifer pointed out. So to the extent you can use different forms, have them signed in different ways, and have them evaluated by different people, and so on. Now, not everybody's got this huge bench of office employees that can do all this kind of stuff, but to the extent practical, look for ways that you can easily show that separation. And the nice thing about using technology for it is, if I've got technology that is built for employees, it's built for I-9s and W-2s and HR benefits and all of those in employee handbooks, why would I try to force that technology to deal with independent contractor contracts and customer addendums and vendor payments and those types of things? It's not designed for that. Use technology that's designed for what you need. And if you're using independent contractors, you need technology designed to work with them, because that relationship is fundamentally different than an employment relationship. So is the technology designed for contracts? Is it designed for collecting LLC information and corporation information and W-9s and paying corporations and paying LLCs instead of paying individuals? Is it designed to let the contractor pick between 2 or 3 different types of insurance or insurance products? Is it designed to administer all of those kind of things? Again, if that technology is designed for independent contractors, if it looks like it's designed for independent contractors to the independent contractor, you really are taking away a lot of that steam, a lot of the force of that worker's argument that they were lied to and misled, and that you're this big bad company that was taking advantage of them. Make technology your friend. Use it to say, hey, this is open and obvious. I'm not hiding anything. This was very clearly an independent contractor relationship with independent contractor pay, independent contractor arrangements, independent contractor technology, and so on. So make it easy on yourself. Use the technology that's designed for it.
That's great advice. And obviously that also, I would imagine, also saves the company quite a bit of resources as far as their own labor in managing these type of programs.
Yeah, something I learned, it really is, I learned early in my career when I was working with a company and we were buying technology, and I had a great CTO at that company. And what he said was, and I think it makes a lot of sense, is he said, hey, if we buy software from a company and it's designed to do A, B, and C, and then we start asking it to do D, E, and F, then we're going to get mad because their software doesn't do D, E, and F very well. And then they're going to get mad at us because we're kind of a jerk customer to them, because we're always mad that it doesn't do D, E, and F. And his advice to me was, if you're buying a software that's designed for A, B, and C, then use it to the maximum ability for A, B, and C. So correlating that to my previous answer is, if you're using an HRIS system, use it for HR reasons and use it for your employees and get the most out of it for your employees. But don't try to make it your vendor payment program or your independent contractor contract administration program, because it's not designed for that.
It sounds like that, you know, putting a square peg into a round hole can end up really costing you in the end, probably much more than you save in having the right resource at the right time.
Yes.
Perfect. Well, I think at this point, it's a good opportunity for us to move into some of our attendee questions. If you haven't had a chance to ask a question yet, then you know, please go ahead and use the question field and feel free to ask those questions. We seem to have quite a few that has come in from our viewers. I'm trying to get this to expand out. Actually, you know what I will do is we have Danielle Olivier on our line with us today, who is with our marketing department. I'm going to ask Danielle if she can go ahead and read that question, because it appears I can't really see the entire question that was asked.
Sure. The first question that we got is, what is the average % increase for a IC versus a W-2, since they are paying their own taxes, insurance, etc.?
I don't know that there's a great average to look out there and say, because so many industries are different and the type of work is different, and the type of pay is different and all that kind of stuff. And there's some things that you would add in extra that are really going to cap out. For example, let's say you're going to bring on an independent contractor attorney, okay? Well, the compensation rate is higher than, say, maybe an independent contractor or landscaping services provider. You are not going to add the same percentage on top to an attorney than you probably would to a landscaper. So so kind of a hemming hawing answer. I know that, but I don't know that there is a great answer. That all being said, if I'm taking a shot in the dark at something like that, I mean, you're probably looking at something in the 20%, maybe a little bit more, 20 to 30% over, because yeah, you got to think that contractor is taking care of benefits, taking care of taxes, taking care of operating expenses, and so forth.
Great. Danielle, can you give us the next question?
Sure. Is there a notification process to authorize an independent contractor background check? It sounds like there is.
So yes, I assume that that's referring to disclosure and authorization. It pretty much follows the same process as an employee request, except the language is going to be a little bit different. So typically you would provide the standard FCRA disclosure for consumer report. If you're doing a more opinion-based reference check or opinion-based employee verification, then you would also include the investigative consumer report disclosure. Honestly, I just include both when I recommend it, because it's better to have that extra disclosure than not have it and then find out that you needed it after the fact. Very problematic. You would also need any of those state and local forms that specifically apply to independent contractors. So off the top of my head, that would be City of Los Angeles, San Francisco, City and County, and then there's others. Again, I don't want to give a list completely off the top of my head, because I would be a very bad attorney if I did that. And then the final authorization for the actual background check itself. And of course, the language could be tailored to fit the independent contractor situation. If that didn't answer the question fully, please feel free to reach out and I can definitely provide more information. And I assume that that was a question for me.
Yes, absolutely. Danielle, what is our next question?
Does changing an independent contractor to an S Corp provide different requirements?
Well, that sounds like a Doug question to me.
Yeah, I don't know that it necessarily creates different requirements other than, so if you go from paying Joe Smith to Joe Smith Incorporated, You need to pay Joe Smith Incorporated. You need to make sure your contract is with Joe Smith Incorporated, not just Joe Smith the individually. So I guess the requirements would just be that if the contractor is an entity, then your relationship is with the entity. It is not with the person. And you need to make sure your paperwork, your payments, your data and so on reflects that that's your relationship.
And to add to that too, from the background screening perspective, you can't actually do like a background check as it's defined under the FCRA on a company. That would be more of a business due diligence search. But that being said, you absolutely can do an independent contractor background check on the principals or the individuals associated with that company. So there are ways to take care of that.
Yeah, Jennifer's exactly right. And think of, a lot of my experiences in transportation. So let's use transportation as an example. So Joe Smith Incorporated is going to provide a vehicle and a driver to make deliveries for your company. But Joe Smith himself personally is going to drive and be the one going into businesses or people's homes or whatever. So your business relationship is with Joe Smith Incorporated. And Jennifer's right, you may want to investigate Joe Smith Incorporated, but you also are likely going to need to investigate Joe Smith personally, because Joe Smith is going to be the one driving the vehicle and Joe Smith's going to be one going into the house, and you want to make sure that they meet your standards and so forth. So in that regard, you are going to, as Jennifer outlined, you make sure you do your authorization forms and your adverse action process and do that correctly. There's a lot of stuff to make sure you do well and have a good process for. You're going to still do that on the individual because Joe Smith's the one providing the service. Jennifer, anything you would clarify about that, or?
Just something that I thought about while you were mentioning that. Say, for some reason you need to provide the background check result report to a third party beyond your company that's contracting with that individual and company. Just make sure that you have the consent of that individual to do so, because otherwise you only have the consent to view those results as that company that's ordering it.
Great point. Great point.
Both really good points. Danielle, what is our next question?
How much training, if any, can you provide to an IC?
Doug, can you address that?
Yeah, I would say you can provide no training to an independent contractor. You should not ever train an independent contractor because training is an employee word, but I'm going to say that a little tongue in cheek. I mean it. You really should not train an independent contractor to do A, then B, then C, then D. What you should do though is, we're going to use a safety context, for example. Okay, you should educate the contractor. Hey, this needs to be done safely. Do it however you want to do it, but it needs to be done safely and it needs to be done legally. To do it safely and legally, here are our recommendations. We're recommending these things because we've been in business for 60 years and we've got 500 people that are doing what you're being asked to do. And over the years, we've learned good ways to do it. Or this customer has shared with us the way they want us to want it to be done. We are educating you. We are coaching you. We are providing best practices. We are providing recommendations. So it may sound like I'm playing semantics a little bit, and I kind of am. But I mean it. Don't make it about the contractor needs to do A, then B, then C, then D. They need to accomplish the end goal safely and legally and otherwise, however it needs to be done. And here are some best practices along the way. If you fail to ultimately do it safely and legally, then we're going to have a conversation about what the consequences are. So to me, you offer coaches or coaching and classes and education and tips and all that kind of stuff. You don't actually advertise or provide training. What you could do as an alternative is, hey, I don't really care how you get trained on this, but you need to get trained on this. Here are 3 vendors that provide this training. Go get the training, bring us the certificate when you're done. That's another way to approach it.
a very good reminder that words and how you define something is very, very impactful and matters immensely in creating that distinction between an independent contractor and an employee.
Great.
Neil, can you share another question for us?
Should an independent contract reflect laws where the independent contractor will be taxed or where the independent contractor resides?
Well, I'll go first, but I'd like Jennifer to chime in here too, because I think this also relates to what background check states and laws to be mindful of when you're running them. And hey, this person lives in New Jersey, but should I worry about New York's disclosure laws and all that kind of stuff? There is no hard and fast right answer, and from my perspective. Again, I welcome what Jennifer is going to say on this issue too. Because you can't universally say the law where the person lives is always going to control. In some instances, that's the case. In some instances, it's going to be where you are, where you operate as a business. In other instances, it's going to be where they work, where do they provide their services every day, or maybe if they're talking about an injury, where they were injured. So I would say is you should be mindful of and you should build your program to comply with the laws where they live, you're headquartered, any place you've got a physical office or terminal or yard or warehouse or anything, anywhere you got a location, and anywhere that you or the contractor are going to be operating. So if that means you're going to need to worry about 15 states, then you need to worry about 15 states. In the corresponding cities and so forth. But Jennifer, I welcome what you might have to say about that.
So I hate to say the usual lawyerly answer, but it really does depend. New York City, for example, it's based on whether they live there and whether they'll be working there. And of course, if the employer is headquartered there as well, there's going to be obligations. But when it comes to background screening disclosures, except for a couple of states, California, and then the main FCRA disclosure, those have to be standalone documents. And Cynthia, correct me if I'm wrong, I don't think it's an issue to over disclose as long as you're formatting the disclosure separately as needed. So I would almost say it's better to err on the side of caution and provide that disclosure and follow those laws, whichever is the more restrictive.
I agree. It's much better to argue why you felt like it was important to share additional information than to be in the hot seat trying to defend why you didn't give that information. So I definitely agree with you. Danielle, I think we have time for one more question. We're getting very close to the top of the hour. So which additional question can you share with us today? And just bear in mind, everyone, if we don't have an opportunity to answer your questions live, we will make sure you get a follow-up response to them. We've had so many great questions today. It was hard to squeeze all of them in. Danielle?
Can you provide an IC with a business email or access to business databases like project management tools?
That definitely sounds like a Doug question. Doug?
So I'm going to interpret that as can I give an independent contractor an email address for my company is what you're asking. And I would say is I would err towards no, but I wouldn't say that's a universal absolutely not. Do not do that. And I say that because remember, all independent contractor tests, everyone in the country, Department of Labor, New York, California, whatever, they're all multi-factor tests. And you really don't win or lose because of one thing. You win or lose based on a variety of things. So let's say I might look at that question again, and I'm interpreting it as, can I give them an email address that looks like they're with my company? I don't mean it as anyway, that's how I'm interpreting it. So I would say is, hey, if practically speaking, this person really does need an email address that is with my company because of the way they're going to interact with customers, or the way they might have to represent us in something, or whatever. You might be able to tolerate that because you're really good on other independent contractor things. The person still has a ton of freedom over how they do things. They have multiple customers. They have other email addresses that they use for their business. And this giving them this email address just helps them facilitate when they're in our world. I wouldn't probably get too fired up about it. I saw a long-winded way of saying my default would be no, but I can envision a factual scenario where I'd be like, yeah, we probably can live with that risk, and let them have a company email address, so to speak, because we're really good on independent contractor status in all these other ways.
It's a great answer, Doug, and it reminds everyone that it's really the totality of what you do and not just one thing that basically creates that distinction between independent contractor and employee. So
I mean, I'm a great example. I am an independent contractor of OpenForce. I have an OpenForce email address, and I don't have an issue with that. OpenForce doesn't have an issue with that, because there's a variety of other ways in which I have my freedom to make business decisions and so forth. And there's plenty of documentation about how independent I am and so forth. So the CEO and I have agreed it's okay for me to have an OpenForce email address.
that's a very good point. Thanks for sharing that. Well, we're just about a minute after the hour. So for everyone who's hung on with us for that extra minute, thank you very much. We greatly appreciate it. We are sorry for going over just a tad, but on behalf of AccuSource HR and OpenForce, I want to thank everyone for joining us today. And I especially want to thank Doug and Jennifer for joining us and lending us their expertise. I hope you all have an amazing rest of your day. Bye-bye.